Okay, this is your exam review, course review, a review of the work that you've done so far. And so what we're really thinking about in this class, now that you've been in it for 8 weeks, are legal classes, the federal courts, and what's called conflict of laws. And so I'm just going to go over some of the basics that you've learned and then go deeper into some of the case hypotheticals that I gave you and give you a sense of what you need to do for your final exam and for your final letter. So we have to start with this, difficulty of just teaching law to non-lawyers, right? It's kind of similar to, say, teaching medicine to non-doctors, right? Where do you begin? Well, you begin with what do students already know? So in both situations, law and medicine, what your intuition is about what you think law is or what you think medicine is not what doctors think medicine is or what lawyers think law is. And so we're kind of starting from that big, huge gap that we're not even really talking about the same thing. And that's largely because of representations that come from about law in popular culture, whether, something as simple as, Judge Judy, when she's doing arbitration, is an arbitrator. She's not a judge in that situation. So why does she call herself Judge Judy? It's better TV, I guess. And so TV is not based in a strict reality, right? If somebody is found guilty on TV, they're not really found guilty in a court of law. And so, the processes are not even really remotely close to the same thing because one is pretty boring unless you're really into law, or it's just not applicable to the kind of things that you see in television. There's different storylines. So we're trying to figure out, it can't just jump into a legal class then. We have to try to build a bridge. So the strategy is to just use your intuitions, but change it about this abstract, incorrect notion of what you think law is and shift it back to, well, what is law? Right? So law is concepts of fairness, rules, and the procedures. So everyone has experience with those three things. And this should help you start to see from the very beginning, and many of you did see this in the first two discussion board posts, that this is exceedingly based on your culture, your family, your beliefs, and your lived experience. And so I have to take that kind of perception that you have and then put you within the constraints that a judge encounters. Meaning, judges can't just do whatever they want. So neither can you as you go through this class. You have to be kind of narrow till you get to the end of the class. So how do we measure success in a class like that? There's two principles then that I would need you to see. One would be that you can show me that you understand this concept of federalism, because we're talking about federal courts. If we were doing local or state courts, it would be a very different set of expectations or learning outcomes. And that you see this as a design that has been rationalized, right? People have thought about this, they've applied different techniques, and that this has grown over 200 years. And one could argue it's been a process that's gone for over 1,000 years. And so, just because you don't like the result of a particular case, or you don't like the fact that Florida has a different set of laws than New York, that doesn't make it stupid. In fact, it's really quite the opposite of that. And so, this is kind of part of just getting used to the idea that what you think about things generally is not typically the way that professionals think about things. They tend to look at special cases, not huge classes of information. And so that's another big difference, right, when you think about, kind of common sense or your everyday experience, and then what professionals like lawyers do. Now, the other thing you should be able to do is identify and explain why the diversity of cultures, beliefs, habits, and economic realities requires flexibility in judicial interpretation. In other words, because we're not all the same and because we don't have the same definitions of things, judges have to respond to that reality, and that people are not going to behave the same way in every single situation, even in their own life, let alone, in comparing 3 or 4 different people. And so you have to kind of get used to that reality as well. So how is this assessed? Your final three things here are going to give me evidence that you've can apply this process. For some of you who've been keeping up with the work, this is kind of what I mentioned at the beginning of the class. You're going to get a 10% boost, but you're also probably going to feel really comfortable about answering the question. So you'll probably go from an A minus to an A, or an A to an A plus. And in a few cases, you'll go from like a B or a B plus up into the A range. And so, probably the hardest part from here until the final exam is really just reducing this information. So one of your assignments is to put it into a one sheet, which will help you do this. But you really have to read the two articles, the social science articles I gave you, both with an open mind, meaning you're not judging the content of it politically, but rather you're looking at the legal processes and the legal language. And that's really the thing I'm looking for. And then you have to think about how you're going to apply that to the legal cases that you've been thinking about. Even if you didn't know those were legal cases in the hypotheticals. So I call this the hangover because I've taught this class for a long time now, and I talk to students after they graduate and after they leave this class. I've had former students who went on to become police officers or other forms of law enforcement, tell me that they didn't like the class at first, but now they see that it's relevant. They just didn't understand it. They didn't have a context. And I tell them I totally understand. That's why I designed the class this way, right? So it would be helpful for you in the long term. If you want to be a lawyer or you want to go to law school, then this is, essentially what you're going to do at law school, and then a baby version of what you do as a lawyer. And then if you have no interest whatsoever in either of those fields, this is probably self-explanatory to you in some ways, right? You didn't really have anything invested in it. And so if I say, there's no formula for legal reasoning like in algebra, you probably agreed with that. The issue is then that means that there is, no way of getting people to change their behavior simply by telling them things. And that might be hard for some of you to accept, but much of social science has shown this to be a fact, right? A scientific fact. So this kind of takes us over to what we should have been studying from day one, if people had already taken a few law classes, right? Like you would at law school. You're really talking about the legal process, right? So you learn how to identify rules, which has really been the fundamental goal of this class, by looking at previous cases and rulings that courts made on a similar problem. And in law school, you're looking at sometimes 30 or 40 cases within a week to really understand what the rules are. And then in a more complicated version of this class, we'd start looking at exceptions, which I do kind of hint at, but I'm not going to grade you on that. I'm just letting you see what that process is. This formal legal process also obviously includes adversarial arguments, which is why there isn't one set standard. And sometimes people say it's like, well, there's two sides. I hope that you're seeing from this that there's more than two sides. Again, this isn't algebra, so I can't tell you there's 36 sides. In general, there are 3 to 5 sides, meaning that there's the majority opinion, there's the plurality opinion, and there's the minority opinion. And then there's usually what's called a concurring opinion, meaning that they agree with the majority, but they have a different perspective. And there's almost always a dissenting opinion, which doesn't agree with any of the other 4. And so, there can be as many as, it would depend on the issue. If you took slavery, for example, you could have probably over 100 different, perspectives legally from the courts. And so the main point is that there's not one rule, there's not 2 rules. There's dozens of rules that apply to any social situation. And this is because this reflects, the actual conflicts themselves in society. So the conclusions that judges make are based on the reasons within the context of what are political facts, and those are left to juries and legislatures, and then the legal issues, which are really the meat of what judges deal with. And then, you have to accept this idea that society's not perfect. It has never been perfect. There is no place. In fact, it's even really difficult to define society. No human is an angel or a devil, and that a code of conduct has never changed those facts, right? Many people have had the Hammurabi Code, the Confucian ethic, Plato's Republic, the Napoleonic codes, the Justinian codes, the Patriot Act. These things have not actually proved to change really much of anything other than how we fund law enforcement and what we criminalize. So I kind of talked about the practical applications, but basically, I want you to start thinking about, especially, as you're thinking about the political debates around policing, which to me are very different than the legal debates about policing. But try to remember, police live under very similar constraints as judges. They're not the same constraints, but it's a similar process of constraints. They have rules, procedures, etc. But they have this, like, something that judges don't have, this incredibly vague and problematic concept called reasonable suspicion. Judges don't have to deal with this nonsense. What is reasonable is always left to juries, so it's always a political issue. So judges don't have to really define reasonable. And secondly, they never have to think about suspicion. Suspicion is a very strange word to folks who are trained in the law. What does it mean to be suspicious? I would require, just hundreds of pages of physical documentation of your behavior for months before I would know when you deviate from your quote unquote normal behavior. And so, reasonable suspicion should only, in my opinion, legally be applied to surveillance cases where police have staked out someone for a very long time and they see them deviate from their pattern. That is, of course, not how it's used in social media or popular culture. And so, again, kind of going back to the challenge of teaching law to non-lawyers. The other thing I think is most useful for people on a very practical point of view is that, people in authority, or what people call powerful people, they can abuse their power. They will abuse their power. They always abuse their power. Anyone who holds power abuses their power. But they're not going to automatically be punished. And even when they are punished, it's very rare that it's criminal. They're not getting prosecuted. They're not going to jail. So this means that if somebody abuses their power in relationship to you, whether it's a teacher, whether it's a police officer, a doctor, almost always you have to sue them in civil court. No one's going to bring a case, right? I always hear that in class. There's bring a case. I don't know how, you bring a legal papers in a briefcase. So I suppose that's, how you bring a case. But you've got to file those claims. And so that means legal processes are just like any other. Those who have the money to file those cases and pay lawyers, guess what? And they have social support at home, meaning they don't have to mortgage their house in order to pay for the case. They're going to win. And haves typically do not win. Have-nots typically do not win. It's a very rare case, and you'd probably need a lawyer to take the case pro bono or for free, which, you get what you pay for is an old saying. So one theory of legal education proposes that knowledge can help defend against abuse and or promote social equity. This means kind of two things. One is that when people know what the rules of the game are, so to speak, they're more likely to protect their rights. They're more likely to vocalize that they know what the rules are. They're more likely to change their behavior. And then also kind of, you think about it, if everyone knows the rules, then people are less likely to abuse power because they assume you know what the rules are. Social equity activity, this means that, in person, we'd all be talking together. Many of you would start to see that you have things in common, and you're sharing information about landlord-tenant law, traffic stops, all sorts of things. And so you start to see social groups start to mobilize, and that's how you really get to movements, whether it's Black Lives Matter or whether it's the Trump supporters and whatever it is they stand for. I think you'll see social movements in time, coming from all sorts of political backgrounds, whether it's the populists of the late 1800s or the civil rights movement, beginning in the 1920s, largely because they start to learn about rights and how to enforce them together, right, as a group. and the decision is made to go ahead and push that agenda. So this is where it really just gets like super complicated then. And that's really what I've been trying to help you with this whole semester, is rather than throw 200 pages at you, let's take the most common thing that you need to know about the court so that you can do well in other classes and in life. And this is the idea, again, going back, that it's not stupid that Florida has a different set of rules than California. It's because the people there are different. They have different expectations. For example, this is a scientific fact that a majority of the residents in Texas speak Spanish, whereas in North Dakota, very few people speak Spanish. So a judicial ruling saying that elementary schools have to teach Spanish in North Dakota wouldn't make much sense. It might be useful for the kids in North Dakota, but it wouldn't really match the democratic politics of that state. Whereas that same rule in Texas would make a lot of sense. And so this just shows you that the country has been divided up into districts, and this goes back to 1787. And the districts obviously have gotten bigger and more geographically broad as the country expanded. But what we're seeing here, I started you off in the Sixth Court of Appeals, and so this gave you a legal ruling from which in fact is a panel of judges that were reviewing a federal district court case. So that's just like in the city and state system, you generally have 3 levels of courts. You have the trial court, the appellate court, and then most of you famously know the Supreme Court, which actually doesn't hear very many cases. The Court of Appeals hears the vast majority of the federal cases. In fact, you might even think about something that it's a kind of a waste of time to even study the Supreme Court as a courts class, because they hear so few cases compared to the federal courts. This is where law is made, the federal circuit courts. And so I wanted to kind of just show you a few things in this little visual. One is that, we're looking at the place where these judges are really setting the standards and the rules for judges within their geographical area. So the Sixth Court, Circuit Court, is, covering Kentucky, Tennessee, Ohio, and Michigan, which is kind of interesting because those states don't have much in common with each other anymore. At one point, they were all on the they're still on the Ohio River, but that river used to be an industrial kind of area, and so maybe it made sense for the Circuit Court to be there. Now those states, are very different. Their populations have voted very differently for things like Obamacare, or for Medicare, or the vaccine. And so the political makeup of those areas is very different than the judiciary. And I want you to think about that they don't always match well. In a place like Texas, they tend to match better. In a place like New York, they tend to match better, even in California. But in these kind of middle areas where it's kind of really diverse and extremely divided, it's not going to be as accurate. The other thing to think about is that, we started this class with what, when I first saw this law and read it years and years ago, it appears to be pretty straightforward to me. I've shown this now to several thousand human beings, and I've learned that everybody has a different interpretation of what they think these words mean. And so, that's what we've been thinking about. And the big issue is going to come down to, how do you apply laws that Congress writes that aren't necessarily as clear as don't go more than 65 miles per hour on a highway, right? That one's pretty clear, I suppose. But this one is not like that. And most laws, of course, aren't that clear. It's very difficult to write a clear law, as anyone with children would know. That's why "because I said so" becomes such a nice excuse. So, why are we in federal court and why are we not in state court? Well, if you go back to that law, it's, 42 CFR, which probably means absolutely nothing to you, except for maybe at the bottom you could see it says, Fed Reg, right? So it's a federal regulations, meaning it comes from the CFR, which is, it has the constitutional protection of the first article, and is, a law made by Congress. And so we are in federal court. As I'm going to talk about later, you could sue in state court. Well, you could sue anywhere, right? And then the other side can ask to have it moved, as you saw in the Amazon case. And they'll have to determine what's the best subject matter jurisdiction. But the general rule that you should think about as a student, again, there's always exceptions, but the general rule you should think about as a student is if it's a federal law or a constitutional claim, you're almost always starting in federal court. There are also advantages to bringing a claim in federal court. It's less likely to have bias, local political bias. It's also, there's certain claims that you can bring that increase the damages, so you can get a bigger payout in federal court than you can in state courts. But largely, again, the laws are different. The federal laws are different than the state laws. So there is no state law like the one you saw about the transfer of individuals. And so this is a kind of a tricky situation. Hospitals are not located in federal land. There's, of course, no place called federal land. They're located in New York. They're located in states. So this is where it gets complicated, right, for judges. If you don't bring a claim in state court and you bring a federal case, then judges get a little nervous because they don't want to conflict with the political process. So this is evident here, right? The legal issue, for the most part, most of you thought is, should the federal law apply in that case? But others of you had a lot of different perspectives, and one of you kind of looked at whether the person is entitled to health care. Now, again, I said this before, but in your American government class or your U.S. government class, you probably should have learned the difference between rights and privileges. And healthcare in the United States is not a right. It's a privilege. Now, Bernie Sanders and AOC, have argued that it should be a right. Sure, right? And we could go down a long list of things that should be rights, but it's a fact that they are not rights. And so whether LJ is entitled to healthcare rights is a political issue. It's not a legal issue. So it's a good issue, but it's not a legal issue. So the issue is the federal law applicable to this kind of a case, to this kind of a transfer? And that's a big milestone for many of you, right? If you were able to get to this place where you're not looking for political issues, but you're looking for just sticking within the law and understanding the difference between the politics of law versus political arguments, then you got to this point. If not, you're going to get there. Don't worry. We keep going over this over and over again. So the real question just becomes then, was the action that the hospital is contemplating a violation of the rule? And so you have to ask yourself, well, what was the action of transfer? Have they done it yet? What are they doing that would, bring the law into case? So, the Sixth Circuit has said that they can't discharge until stabilized. So within this district, what the judge is really thinking about is, if I allow the hospital to transfer the patient to Guatemala, is their condition going to get worse? Now, this is like future predictions, right? So you're trying to take in probabilities, you're listening to expert witnesses, what doctors are saying, what the hospital is saying. You might reach out to the government of Guatemala and ask them what they think. And so, you'd have to make your decision based on that legal rule of that court, not anything else. Just simply, is his condition likely to get worse? If the answer is yes, then you're going to deny the transfer and you're going to rule that the federal law applies. If you feel like the condition is not going to get worse by the transfer, then you would say that the federal law does not apply and that the transfer would be entirely up to the hospital. Now, this does not mean that that's the end of the legal argument. There could be other laws. State medical malpractice and healthcare laws are, again, different depending on which state. So it would really depend on, are you in Michigan? Are you in Kentucky? Are you in Tennessee? They're all going to have different rules in different states because they have different populations, and those people have voted for their legislators to pass laws the way they want them to, just like, people do here in New York, whether you do or don't. But because this class is focused on the federal laws, we're not going to talk about those state claims in those state processes. You can take more classes on that. There's only 24 hours in a day. So this is where I think, I wanted to make it more fun, at least for me. Most of you are interested in wrongful conviction, policing, Fourth Amendment, and so let's throw that in here. So I thought, this is a political issue. This isn't really a legal issue at this point. So let's go with you. You all are basically saying that you would deny the request for medical records. And so, in essence, the Fourth Amendment should apply to the medical records. So let's take that as the political fact that you are the representatives of the Sixth Circuit, and so the Fourth Amendment does protect medical documents. So we move on then, but now we're going to transform ourselves over from the Sixth Circuit over to the Fourth Circuit. And in the Fourth Circuit, they have a different rule. And so theirs is based only to the immediate aftermath, which means the transfer itself. So as soon as the patient is gone, it doesn't matter if their condition gets worse. If you're curious about this case is dreadfully awful and sad, but it's the Morgan case. So you'd look up, or I could email it to you if you're really super interested. But this poor guy injures his back. He lives in a different state. They cross state lines, and he dies in the other state, right? The state where he lives, not the state where he was injured. And so that's the court said, well, what could this hospital have done about that? Some of you could, you would say, well, a lot. They could have done a lot. But what they mean is, what could they have legally done about it, not what they could have done, within the power of medicine. So here you're just looking at, what would the hospital need to do in order to transfer LJ to Guatemala? They'd get an air ambulance. And so basically by the second they step down out of the air ambulance, whatever happens to LJ is no longer the legal responsibility of the hospital if we're in the Fourth Circuit. So if we're in the West Virginia, North Carolina, and South Carolina. And then, I asked you now to bring in back the Fourth Amendment. Should the map be used as evidence? And, the majority of you said no, but a minority of you said yes, right? So notice here, though, that the legal issue changes because we've moved circuits. This question really wouldn't apply in the Sixth Circuit because he wouldn't have been able to be transferred. But now that he's able to be transferred, the question will be, well, what is the basis of the transfer? Well, why would anyone in Virginia transfer somebody to another country? I guess two reasons come out to me. Number one is, many of you are probably thinking they're from that country. The second issue could be you get better treatment, right? So if you get injured and you're doing some, let's say, a volunteer trips in a different country and you're in a really rural agricultural area, they don't have any hospitals, you might benefit from being transferred back to New York and being operated on there. In either situation, what we're looking at here is, what is the map going to show? The map is trying to show without, they're trying to get around the Fourth Amendment here. They're saying, well, LJ, we can't say what LJ's national immigration status is, but what we can show is that at this hospital in this part of the country, there are a lot of immigrants, undocumented and non-citizen immigrants, that would benefit from being transferred to their country of origin. And so therefore this map helps show the numbers and why the hospital engages in this kind of practice in the first place, or why it's economically feasible for them to rent an air ambulance and take somebody back to Guatemala or West Africa or the Philippines, right? I mean, the further we go, the more expensive this gets. So the question then is a political question, right? Is immigration status reasonable? And that will depend on your local jurisdiction. I think if you ask that question to New Yorkers, as we did here, most of you said, no, that's not reasonable. In Virginia, North Carolina, I think you're going to get a different answer. People are going to say, absolutely, that's reasonable. But notice, this is not a matter of law. There's no legal standard for admitting maps of immigration in cases like this. And so judges don't make these decisions. They leave them up to juries. And so, that's something to think about. So what is the judge really doing? Well, the judge is going to decide not whether it's reasonable, but whether this is prejudicial. So it might be relevant, and the jury might decide that it is relevant. But before the jury can make that decision, the judge has to decide whether, if it was accepted, would it prejudice the jury? Would it make them focus on a political issue instead of a legal issue that harms the process, basically? And, these are the two arguments that each side would make, and the judge would have to make their decision, again, on not maps and not immigration, but on evidence that is prejudicial. What's the standard? How prejudicial does it have to be? Which weight are you going to give to which side? Is it going to be more about the evidence being relevant, or is it going to be more about it being prejudicial? So now it gets obviously more complicated, and judges get nervous because now we're talking about the constitutional right of the Fourth Amendment. If medical records are protected by the Fourth Amendment, and let's say the Supreme Court has ruled on that, then I'm, as a judge, even if the jury would want to hear this evidence, and even if it's relevant, I'd be nervous that LJ is going to bring a Fourth Amendment claim, and I'm going to get overruled because immigration status is in the same file as the medical record. And if they're in the same file, then they're probably going to be treated the same way and both protected. So Megacorp would have to convince me as the judge that it's more relevant than it is harmful of their Fourth Amendment right, and that there have been judges who have been on the favor of allowing certain medical records. In other words, saying that the Fourth Amendment doesn't always apply, that there's exceptions. But there are two other options if Megacorp wanted to pursue them that have nothing to do with the judge. And they're either non-legal or extra-legal, depending on how you want to define it. But I could just leak a rumor that LJ is undocumented, and I don't have to go to the trouble of entering the evidence. I don't know for sure that the jury is going to find this out, but if I place it in some well-placed newspapers, maybe I get an interview on TV, there's a good chance that at least 2 or 3 of the jurors will hear it, and then they'll bring this issue up, whether it's a legal issue or not. So, I have that option. It's not fair, but it's not illegal. Or I could recruit a DHS agent to just go ahead and begin removal proceedings, and then those records would be public, and then I wouldn't have to worry about the Fourth Amendment. To me, these are ethical questions. They're moral questions, but they're not legal questions. They obviously have an impact, but there's not really anything a judge could do about either of those. Now, should immigration status be protected by the Fourth Amendment? You are split, which is pretty interesting, but it's also pretty relevant. It mirrors what's going on in the political debate, I think. On the other hand, you were very clear that you think medical records should be protected. I think this is why we call these political facts. There's nothing legal in this. This is going to be, what do you think of the political climate? So I'll leave it at that. I mean, I just wanted you to see that this is, representative of what we're seeing in the larger arguments. What I think is probably surprising to most of you is that question has nothing to do with judges. And so many of you project powers onto judges that contradict your everyday experience. In other words, in your first two discussion posts, you allowed for the fact that your friends and family members have different perspectives than you. But you seem to have wanted to require that judges have one standard all the time. None of us do that. So this is why we try to keep political issues separate from legal issues. And I've given you a quote here from the American Bar Association. They're trying to sort this out themselves as recent as 2029. So, it's tough. Politically, people seem to like the concept of reasonable suspicion. It comes up in my class, almost to the point where it really irritates me because it's not a legal issue, right? So it's like going into a medicine class and you're talking about olive oil, right? I'm sure it's good. There's studies that show that it has benefits, but it's not the subject matter of the class, right? I mean, olive oil is right. Thing is, that's a culinary class. That's a cooking class. Reasonable suspicion, that's what police do. That's not what lawyers do, and it's not what judges do. But politically, people seem to be in favor of it, which, this is the contradictions that judges and lawyers always have to deal with. On the one hand, the public seems to be great with reasonable suspicion. They give that ridiculous power to police officers. On the other hand, they don't like it when police think people are suspicious and shoot them. That's a psychological question that does not have a scientific answer, at least in the year 2021. And so I think this is why lawyers and judges stay away from this, or we look at the aggregate, right? So if I see that young black men and young Latino men are disproportionately getting shot and are being accused of being suspicious, then I see that as a larger problem, right? That's not a problem of an individual police officer's psychology. That's a sociological problem, that there's pressures on police officers that are probably unreasonable, to make a little bit of a pun. But again, we've only been playing around with this reasonable suspicion thing since the 1970s. Before that, you'd be rare to find a judge who would go against a fundamental right, like the right to privacy. So, these are things to think about. Politics and lawyering are not always on the same page. So, as we're kind of concluding here, then go back to what you already knew. Well, the problem is that no one knows that much. Humans are really bad at assessing other people's behaviors. We largely try to give people attributions of psychology, and we don't have any idea what's going on in their life or their mind. And so we're almost always wrong. That's why good poker players pay attention to numbers and probabilities, not what they think other people are doing. All humans tend to overstate our own abilities. So we think we're going to make way more money than we're really going to make, even though we don't even know what the average income is. So we think we're above average, but we don't even know what the average is. We all care about very different issues, and we want Congress to solve that issue, and we want the judges to solve that issue. But there's fewer Congress people and judges than there are in the population at large, and so how do they even decide which issue they're going to take? I tell you one thing: they don't do surveys like I do in this class, right? So a judge might say, well, 44% of the students think we should focus on wrongful conviction, so let's focus on that. But they're not doing that, right? So they should read my papers, right? My published papers. But, even if we could assume that we're all going to focus on wrongful conviction, even if we could all assume that everyone should make $75,000 a year to start, how do we define, is that the good life? Because there's going to be some people who don't want to do that. And so because people have different definitions of this, what good behavior is, what good living is, what good expectations are, judges are always going to be in this very difficult position of not wanting to get involved in political arguments. The other thing is that most humans really don't know the basic legal and economic facts. They haven't been taught those things. They don't experiencing them. So unless you learned about these things, it would be hard to give an accurate description of what would be a solution to a cause. And so many humans believe, without evidence, for example, that someone or something sometimes is going to end up helping them in the end. And they use that language. In law school, sadly, in criminal law, we learn that never happens. The person almost always dies. So these are the complications that I've been trying to get you to see that the judiciary can't solve. Right? Judges can't make humans, because they're humans, right, better at predicting human behavior. What you've been kind of learning how to do now is to apply social science knowledge so you could be better at making predictions about large groups of people. So in the first reading on the key of law, you're gonna learn mostly about rules and fairness as like the basic blocks of legal knowledge, and that's mostly visible and evident if you're paying attention everywhere you go. People have, probably one of the funniest things you could do is go to a grocery store and just, I don't want you to get in trouble or anything, but you're standing there and just watching people get in line, or online, as some people say here. And it's kind of silly that people have different ideas of what they think is the appropriate way to wait in a line, to stand in a line, to move forward in a line. I think it'd be fascinating to compare that to the 6-foot rule now that suddenly appears. Some of you have probably been in an experience where people were way too close to you. And now there's a rule that says you can't be. So you see this kind of process everywhere you look. But what I really want you to focus on is how do they make the rules in the game of basketball that they're playing is kind of one at a time, right? It's not, they don't sit down on a Thursday and say, well, we're going to come play on Saturday, so let's go over all the rules. Let's study the rules. Let's read about the rules. Let's read a few books about rules. No, right? They show up and they start more or less making up rules as they go. Children do the same thing. So you can go and watch them at a public park, and you'll watch them inventing rules, right? Now, they're probably borrowing a lot of these from home, from what they see in TV, things like that, just like we start off this class, right? Your intuitions are not wrong. They just need to be redirected towards different processes and institutions. The second one really gets to that issue, and so I don't want to tell you too much about it because I really want you to read this one with an open mind and start to think about, look for this as Black Lives Matters is resisting to a long-term abuse of power. Some of you think that this just occurred last summer. This resistance is a long time in the making, and it reappears, right? There was the slave rebellions, there was the Jim Crow rebellions, there was the new Jim Crow rebellions, and so in many ways this is not new. It's just when the abuse of power gets so heavy, you'll see people resist. And so that's what I want you to look at is, how does this First Amendment protection, for example, to free speech and to protest come about? It's the same process as the key of law, the same process as the lawyering, but it's like a different end of the spectrum, if you want to think about it that way. And then start to think about this concept of a lawsuit. It's a federal lawsuit you bring in federal court, based in the arbitrary and capricious use of power. It's an underutilized tool. Not a lot of people use this lawsuit. And I think there'd be a more social change if people use this more often. And last but not least, I just want you to think as the very last circuit that you look at on the same legal issue. Is the Ninth Circuit, which is the biggest circuit, and it has a pretty big impact on the Supreme Court. The thing to think about here is that judges are mostly, as you saw in this class, making rulings on evidence, what gets in and what gets out. The abuse of power is very, very, very common. It happens all the time. So knowledge of laws, it protects against this abuse in one sense, but you'd have to enact those legal protections. And that's through lawsuits, legislation, or group mobilization. And group mobilization, in my own research, generally falls after legislation doesn't do the trick, or a lawsuit doesn't work, right? Then people start to see this, right, in different circuits. So people are suing in California, they're suing in New York, they're suing in Florida. They find out that they're suing, and they say, well, why don't we join forces and try to make this a bigger issue so that it's not just a state issue, so that one state is okay, but then 22 other states are terrible. The other thing is that you have to separate political issues from legal issues. This is really hard. There are some studies that would suggest that judges don't actually do this in their minds or in their writings, but they do it through the process. The process does limit politics in the legal cases. And then there are no universal truths in law other than that one. Law is not about trying to find an answer or find who's guilty, or some of these things that are lovely in TV shows and movies, but not in courtrooms. So legal reasoning is really just minimizing, or we usually use the word mitigating, the conflicts that are already in society, that groups are bringing, and we're just trying to reduce them down to a manageable number of issues, so that you can come up with a solution, so you're not trying to solve all the world's problems in one day. That's a lengthy explanation of what you've been studying and what I expect for you to be able to do in the remaining few weeks. I will probably do at least one group session with anybody who wants to join to talk about these things and help you finalize these issues in about a week and a half, to give everybody enough time to get through those 2 readings. I'm going to make that kind of a requirement, that not that you should have read and understood them, because it's fine if you started to read it and you're struggling with it and you need some help, but at least have it available. If you're going to join one of the sessions, have the reading ready and ask me specific questions about it, because it's an expectation that you're going to be able to use those 2 social science readings in your social science class. Okay?